Dr. Shakuntala, for nice introduction and giving me the opportunity to moderate the panel discussion on the deposition in the court. First of all, let me welcome the expert of this session, Dr. Shada Jain ma'am, Dr. Shadna Gupta ma'am, and Dr. Sangeeta Gupta. All of them are being well known and they are already introduced by Dr. Shakuntala. Hence, here I want to appeal once again to each and everyone who are there to vote for Dr. Shadna Gupta for the presidentship proxy in the coming election. My best wishes for you, ma'am, Dr. Shadna. And it is my privilege to introduce the panelists of the session. First of all, I welcome Dr. Gaurav Agarwal. He has been already introduced by Dr. Shakuntala, but just want to say a few words for him that he is a great humankind and spiritual person, always easily approachable and very helpful round the clock. A doctor come advocate practicing as a medical legal expert, consultant, and he has a passion for increasing the medical legal awareness for safe medical practice. My next panelist is Dr. Leena Sridhar, young buddy with beauty, very active in Kanun Ki Pathshala, and done the postgraduate certified course on the medical legal subject from the Delhi Gynae Forum Medical Legal Cell. She is the senior consultant, Ops and Gynae and HOD academic and research at Manipal Hospital, Dwarka. Delhi. I feel very happy to announce that recently she has received an appreciation special award for her 5-year commitment, care, and compassion at Manipal Hospital.
Thank you so much, Dr. Raj.
I also welcome Dr. Shashilata Kavra, a great academician and teacher, senior specialist ops and gynae and NB teacher at DDU Hospital. She is also a TOT forensic and medical science of the survivor of sexual assault, recipient of so many awards by various organizations, a very focused and dedicated person. She is well known across the India for her prevention of maternal mortality from PPH and organized more than 65 workshops on PPH all over the India. Once again, I warm welcome to Dr. Shashilata Kavra. Next is Dr. Anita Rajoria, a very great friend of mine, HOD and senior consultant Ops and Gynae at Hedgawar Arogya Sasthan, Government of NCT Delhi. Very dynamic and well-known person, associated almost all the organization and societies. Very difficult to enumerate her achievements, position and awards. She is also a national TOT for examination of accused and survivor of sexual assault and evidence collection. Welcome, dear Anita.
Thank you, ma'am. Thank you so much.
And she's also the chairman of Public Awareness Committee and IGF.
Thank you. Thank you, ma'am.
She is at so many places, madam. Lastly, I welcome Dr. Milanli Mani, our last panelist, HOD, Ops and Gynae, Guru Govind Singh Hospital, and founder, President, DGF Southwest. She is associated with many societies and also faculty in National Institute of Criminology and Forensic Science, Police Training Center for Crime Against Women. Welcome, Dr. Milanli. Now, after the first session, we had a very exhaustive and nice, excellent deliberation by Dr. Sangeeta Gupta to how to frame the medical opinion in cases of the sexual assault. I'm sure after listening to her, everyone must be clear in their mind to handle and make opinion in such cases. And once the medical opinion is done, it becomes equally important to know the procedure, how the deposition in the court is going to be done. A deposition is a legal procedure and is an undertaking or oath undertaken by the writing to an authorized officer of the court. To appear in the court is very frightening to we as a doctor, but there is no need to be get fear and afraid. It is important, rather it is very important to do all the preparation before appearing in the court and get ready with the medical evidence to answer the questions asked for in the court. The medical evidence deposed by the doctor has an important role in the final adjudication of cases of the sexual violence. So, to start with, my first question goes to Dr. Leena. Um, is the doctor taken as an expert witness in the court?
Hello. Yes, yes. A doctor is an expert witness whenever she is giving she or he is giving an opinion on the matters of medical science. That means that when they are talking about something related like medically, then we are expert witnesses. But for all other things, we are an ordinary witness. A doctor is very much capable of drawing a conclusion, giving opinion from those facts that were observed by himself or herself in the course of the examination. And this is very important because the medical evidence that is given by the doctor, it finds a very important place in the final report that is brought out in cases of sexual violence. So it's therefore very important that we should be very well prepared and we should be equipped with all the medical evidence so as to depose in cases of sexual violence. This will also obviously help in getting justice for the victim. So this is a very important role that we have as an expert witness.
Very well said. Very well said, Dr. Leena. So accordingly, the doctor is an expert witness, and he is a highly educated and skilled person. Apart from the common witness person who can be an uneducated also, and he sees and give the witness only the evidence which are seen by him. But as a medical expert, the doctor is can give the opinion based on their evidence collection and also on the opinion based by the forensic lab and other expert opinion. Now, my next question is, Dr. Leena, to you again only. Should the court always treat evidence given by the doctors as evidence deposed by an expert witness?
So this is actually the same thing. Basically, as long as the evidence which is given by the doctor is pertaining to the medical science, then that particular evidence is treated as being deposed by the expert witness. So it's only the medical, the matters or the medical part that can be treated as an expert witness, not for anything else. So no other comments, nothing that are given, as part of the case would be considered. That is what would be as an ordinary witness. So this is to be very clear that it's only the medical sciences or the evidence relating to the medical science which is treated as an expert witness.
Yes, thank you, Dr. Leena, for making it so clear that as long as the doctor is deposing evidence on the maker of science, the court considers it to be done by a medical expert. Next. So my next question I'd like to ask from Dr. Minani, after getting the becoming as an expert witness, what is the procedure in routine and to call the doctor as a witness?
Yeah. So normally what happens whenever a court has to call a doctor as a witness, first, depending upon the MLC, who made the medical MLC and the names and stamps are already there, the court send a summon to that particular doctor and they try to contact the doctor, send summons, and this summon has all details of the case. So there is a date written, time written, which court, who will be the judge, everything is there detailed on that summon. And sometimes, like in a government hospital, what happens, our residents, they go away. So when we tell them this particular doctor is now no longer with us, they ask us for their addresses and telephone numbers. And we give them that. Even if they contact them or they are abroad or not feasible to come, then the summons is sent to the MS of the hospital to depute the second person, any of the HODs or whoever the special senior person who was present during that time of the tenure of the doctor, to identify the writing and depose on that behalf. And then what happens is, if this summon, we have to honor that summon. That's a legal obligation, legal duty rather. So we have to go for this summon. And also, like your second question was, directly warrant a doctor. So normally what happens is, if suppose there's someone against a doctor, I am called and I'm not able to attend. Without informing the court, I just don't go and absence myself. So suppose I'm busy that day, I can always request the court to give me a second date, which normally they honor. They do honor that. But if without any information, I absent myself, in that case, the court can send a warrant to a doctor, and then it becomes duty bound to attend that. Otherwise, we are punishable. And sometimes what happens, even if only one witness is left, be a doctor or any other, only one witness is left sometimes, then the court can directly send a warrant bypassing the summons, so that the precious time is not lost and the conclusion can be done. So that is by and large.
Can I have the next slide, Malti?
Ma'am, till what Dr. Mani has said is very, very important.
So this is a summon is usually issued. You have rightly said, Dr. Minami. But once you fail to appear, then they can issue a warrant directly also after the summoning. But usually it is the first summon is being issued to the doctor and followed by the warrant if you don't appear due to any reason. And sometimes, as you rightly said, the warrant can be issued when all the proceeding and all the witness part is over. Then it can be summoned directly to ease out and to fasten the process.
Madam, the
Now-
language first is summon, second is notice, and third is warrant.
Yes. Ma'am, can I ask a question to Gaurav sir here regarding the summon?
No.
Recently, we have faced this issue that the deposition, the summon is being sent and we are sending a resident for the same. Now, what they are doing, 2 or 3 times this has happened, that the judge herself is on CCL or is on some training or is not there. So, what is to be done regarding that? How can we request the court that we should be at least informed? Heavy OPDs we are sending these, and then they are not there. The reverse is true, that we may get caught, that there is contempt of court. So, what we can do about it?
So I understand your question. So it goes like this, that judges are above law. That is one. वो CCL पे हो या मौज मस्ती कर रहे हो, वो उनकी इच्छा है. But we are answerable because the summon is sent to us. The notice is in our name. The warrant is in our name. Okay. Secondly, I would like to know कि वो किसके नाम में नोटिस आता है. अगर वो हमारे नाम में आता है तो हम किसी को डिप्यूट करना थोड़ा सा रिस्की होता है, अनलेस यू नो somebody is an administrator या आप एडवोकेट के थ्रू आप किसी को डिप्यूट कर दीजिए, ठीक है. कई बार रिकॉर्ड क्लर्क के नाम आता है. सो इफ इट इज ऑफ रिकॉर्ड क्लर्क, देन एनी रिकॉर्ड क्लर्क कैन, it is very routine for a court to expect the other person in place of a doctor if that doctor is indisposed of due to whatever reasons which are official as far as government is concerned. So it is very
The courts have become smarter now. They are sending the summons in name of MSs now. So we have to depute some because our residents are leaving, as Manali ma'am has already highlighted.
so MS cannot
They are
go anywhere every time. MS has all the power to depute anybody who he thinks proper. Basically, if they want just to attest the signature of the person who has signed that report in the court, then even a record clerk can go. If they want somebody to give a particular opinion, then the MS has to depute a responsible doctor in that specialty. Yeah, Dr. Kishore?
Yes, may I add something?
I just want to say that actually every court जिसका भी होता है ना, जैसे 30,000 है या रोहिणी कोर्ट है, so we have उनका हमारे पास उनके जो ऑफिस के उनके क्लर्क्स होते हैं, I don't know, readers, somebody is there उनका नंबर हमारे पास है, एंड वी ऑलवेज कॉल. जैसे हमारे समन आया आज का, तो वी ऑलवेज कॉल इन द मॉर्निंग, और जनरली समन आ रहा 2 PM. मोस्ट ऑफ द टाइम डॉक्टर्स को ना 2 बजे बुलाते हैं वो.
Yes.
तो वी ऑलवेज कॉल कि है कि नहीं आज. मोस्ट ऑफ द टाइम वी कम टू नो वेदर the judge is there or not. In 99% cases we come very to know. Rarely ऐसे होता है कि वहाँ, but and the regarding that appointing someone else, तो वो सर it will depend on case to case also. And वैसे जनरली तो यही होता है कि आप इसको 100 को जानते हो. Some judges are very particular. I went for अभी last 3-4 days back I had gone to Rouse Avenue Court. वो संदीप वाला था ना, आप वाला जो रेप केस था, जो आपका जो मंत्री था उसका, तो उसने then the judge asked me, मैं तो गया था बिकॉज SR had made it. Judge asked me whether have you made. मैंने कहा no, I have not made. The SR has made. तो कहते the defense counsel is asking me that were you present when I have appointed that and I know that she has made it. वो कहते नहीं जी, आप उस टाइम प्रेजेंट तो नहीं थे ना जब ये MLC बना था. मैंने कहा नहीं, मैं तो प्रेजेंट नहीं था. मैं ऑलवेज चेक करता हूँ नेक्स्ट डे आके. सर जजेस कैन डू लाइक दिस कि उसी को बुलाओ. ये बड़ा प्रॉब्लम है हमारे को. मतलब काफी देर मेरे से बहस करता रहा वो, बिकॉज क्रॉस करना था ना उसने.
हाँ, तो वी कैन ऑलवेज सेंड समबडी फ्रॉम दैट डिपार्टमेंट. कैजुअलिटी डिपार्टमेंट है या वो गायनिकोलॉजी डिपार्टमेंट है. हाँ हाँ, तो if that not traceable, then you can simply say we do not know about the whereabouts that person he has left.
हमेशा होता है, पहले समन डॉक्टर के पास आती है, हमसे पूछते हैं, वी गिव देम टेलीफोन नंबर्स, इफ नॉट ट्रेसेबल फिर वो MS के नाम आती है कि MS टू अटेंड और डिप्यूट समवन, एंड दैट व्हाट MS डज. एंड द कोर्ट ऑलवेज आस्क्स if they want वो ढूंढे उसको. फिर
सर समन के बाद वारंट आता है, और वारंट एक पहले आता है बेलेबल, दूसरा आता है NBW नॉन बेलेबल वारंट भी आता है. सर आपको कई आगे बुला लेके जा सकता है.
तो सारे रेजिडेंट के टाइम में हम ही लोग जाते हैं. वो कुछ जजेस तो इंक्लूडिंग वो 10 साल पुराना रोस्टर मांगते कि बताओ वही डॉक्टर थे क्या. So they can be very unreasonable sometimes.
I think it is. अपने पास एक रिकॉर्ड जरूर होना चाहिए परमानेंट.
Dr. Shashi wanted to say something. Dr. Shashi?
Yeah, Dr. Raz, am I audible? May I add something?
Yeah.
देखिए, मैंने GTU हॉस्पिटल में मैंने बहुत सारे कोर्स अटेंड करे हैं, तो उसमें एटलीस्ट 50 to 60 कोर्स मैंने ऐसे अटेंड करे जहाँ पास्ट में किसी आसान ने करा था, MLC बनाई थी.
सारे होते हैं वो.
We were summoned because we recognize their handwriting. उसमें कोच की एक पर्टिकुलर लैंग्वेज होती है that during this and this time this doctor worked under my day-to-day supervision, और वो एक पर्टिकुलर लैंग्वेज लिखते हैं and I recognize their handwriting in my due course of time. और उसमें वो क्या करते हैं, खाली हमसे उसका जो MLC बना हुआ है वो रीड आउट करवाते हैं, जिसको कि हम रीड आउट कर देते हैं. उसके बाद वो फर्दर जज भी हमें बहुत ज्यादा क्वेश्चंस नहीं करते हैं, और काउंसिल जो वकील है वो भी नहीं करता है. कुछ 1-2 कंडीशंस ऐसी भी है मेरे साथ कोर्ट में कि जबकि जज वांटेड टू नो द मीनिंग ऑफ दैट पर्टिकुलर स्टेटमेंट व्हिच द SR हैज रिटन, तो हमने उसका मीनिंग उसी भाषा में जो वो लिखा है उसी के इन्फ्रेंस में उनको बता दिया, एंड दे वर हाईली सेटिस्फाइड. तो ऐसे, और हमारे यहाँ एक नियम है कि जितने भी समन्स आते हैं एज पर मिस्टर गौरव अग्रवाल, वो सारे हमारे MS MD के पास आते हैं, और उनको पूरी पावर होती है वो किसको डिप्यूट करेंगे, कैसे करेंगे, हाउ दे विल से. तो जो रिकॉग्नाइज होता है जो उसको उस हिसाब से.
So in such situations, I would, Dr. Sangeeta, yes ma'am.
मैं तो ये कह रही थी कि we should think about the process in a simpler way, because it is really not so difficult and not so means तो हम लोगों को कभी बहुत ज्यादा प्रॉब्लम नहीं होती है.
Such cases, number one, the doctor is helping the state, the government, the court. So judiciary, जब भी कोई issue हो, just look up to the eyes of the judicial officer sitting there. They are very helpful for a doctor. Number two, if we are in a situation, as Dr. Shashi was mentioning, that if we are asked to interpret or to ask to answer in a cross-examination any question put up by the defense or anything relating to that report, golden rule सिर्फ एक ही है: never go beyond the report in front of you while answering. the answer should be from the report itself.
correct.
Sometimes they ask hypothetical questions. पूछते हैं कि अच्छा बुलेट लगी फॉर एग्जांपल तो एनाटमी के क्वेश्चंस पूछने लगे. अब माय एनाटमी इज एज ओल्ड एज 25 years, but I cannot say this in words in the court. I will say that for anatomy questions, a right person to answer would be an anatomist. Secondly, you can ask me any question relating to my examination or anything that is in the report, not outside that report. I cannot answer hypothetical question. So this is the golden rule that will save your us in the court.
Sir, we
I
always
think we should
mention
move
if they
ahead.
ask us as per records available, the MLC, we then answer the question if they ask. Like Dr. Shashi rightly mentioned, we have never faced a problem as such. One or two people can be fussy.
Message should not go to the doctors or to the gynecologists that the deposition is good. It's very difficult.
It's very easy.
Or we are harassed. It's not like that.
It's very easy, and they respect the doctors also.
Yeah.
They are very.
And in case of any doubt, we can seek help of the judicial officer. Sir, what to do now? So they are there to guide you, even if we do not know anything about the court procedure. They are very helpful for us.
Yeah. And there is a provision of deposing online also, because one of my resident got transferred to South India, and they arrange for online deposition of that. So there is a provision if the facility is there.
तो वो समन में ही होता है ना, वो तो समन में ही होता है.
Because the concerned doctor requested that because I am now far away from my original place of working, so the judiciary, the person you mentioned, he helped her out and he arranged for deposition online.
Dr. Ita, during COVID times, most of them were online. Some courts have retained that online system, but most of the courts are now reverting back to physical. The doctor is away, then there is somebody else to come from the hospital.
Yeah.
Thank you so much to all the panelists for such an interactive session and a very nice clear message ki don't get worried with the summon. Be prepared. Everything is written on the summon about the date, time, what all you have to carry, and in case of anything, any problem, you can always take the help of the judicial department. Now, my next question is to Dr. Gaurav only, because once we get a summon, now how a doctor should appear in the court, with what all the preparation he has to make it. So can you elaborate, Dr. Gaurav, please?
Okay, so this is a simple one, Dr. Raj. Thank you. So as far as preparations, just go through the report nicely. And if it is not a report made by your own hand, some junior or some colleague, then again, just go through the report 2-3 times. And in your mind, just make sure that what are the anticipated questions, So those anticipated questions and answers to that in your mind are going to help you a lot. And second would be that if you are not familiar with maybe certain things that are there in the report, for example, if it is an incomplete report, you have referred the person to an X-ray or to some other specialist, or some specimens have been sent to forensic science laboratory and those results are awaited, then be prepared in your mind that you are going to ask things relating to them, and simply say that I can only give my final opinion if I have those reports. And then in the court, sometimes they produce that report instantaneously in front of you. Go with a cool mind, and then we can answer accordingly. So that is all and again, of course, as I said just a minute ago, that if there is any issue at all, if you feel uncomfortable with any question in the cross-examination, then you look up to judicial officer for help. They are going to guide you. If you do not like the behavior, the attitude of the defense advocate is trying to demean you, to demoralize you, or to make you nervous. Sometimes aise hota hai, especially when we are young. See, in my first or second, I did make mistakes. I kind of became nervous. So if it is the first or second appearance in court, it might happen. The only way to handle such situations is take help of the judicial officer and just make sure that the entire report is in front of you, and don't try to deviate from that. That's it, Dr. Shakuntala, Dr. Rajkumar.
Very well explained all the various important points. It's just like how we are preparing for our exam. So we get every points and everything in detail, well versed with all these points. And then in case of any problem, we can ask and the help of the appropriate prosecutor person, and he is always there to help us. And
Public prosecutor, yes, we can ask for. Sometimes it so happens that we might not have
we
a
can
copy of the report, or we did not get a time to see the copy of the report in our department or hospital. So we can ask the PP, public prosecutor. They will give us the original file from the court, and just make sure that you don't have a pen or pencil in your hand. Because if you have it, he's not going to handle. He'll say कि डॉक्टर साहब इसको दूर रखो. गलती से भी पेन टच नहीं होना चाहिए, because कोर्ट की ओरिजिनल फाइल होती है. You take your time, 10 minutes. If you want, they will give you 10 minutes. You sit aside, आराम से.
We can discuss with them. We
Yes.
can always discuss with them and find out what questions are going to be there, and we can get prepared for the answers well in advance.
May I add something? Dr. Raj, may I add something?
Sure.
Many times I have attended the court summons. One thing is very important, that when the discussion is going on verbally, you can speak whatever you feel correct at that point of time. Then a person will type your conversation in a typewriter, and then you have to sign that letter before finalizing.
Anita, I'm just coming to that point. So
You have to
see the next question to be asked by Dr. Gaurav only. That,
Okay.
that again,
Read that.
there will be no better person than him to ask us and highlight about how the procedure is being done of deposition in the court. Dr. Gaurav?
How an evidence of doctor is recorded in the court.
Yeah. We want to know all the
Normally,
details.
yeah.
Not anyone of
So-
us most of us have never been in the court.
So the answer is long, but I'll cut it short for the brevity of
I have
situation.
kept an empty slide for it, Dr. Gaurav.
Okay. So normally it starts with when you go to the court, you are supposed to inform the Nayab court or the person in the police uniform in the court that I am so and so. Show him the summon, and then he'll mark your attendance. If you do not mark your attendance, you keep sitting there. Then it can, sometimes whenever you arrive there, many courts are very respectful of doctors, and they will take up your case on priority. Otherwise, अगर आपका केस 1 या 2 घंटे के बाद आएगा तो आपको बैठना पड़ेगा. So it is very important. First thing, mark your attendance with the person in the uniform, police uniform, the Nayab court. Secondly, whenever your case is called up, you know the title of the case, state versus ABCD. So you go there, and the TP will ask you, and you have already seen the file as just discussed. So you know why you've been called. You know your report, and you know everything about the case. So it normally starts with oath from the side of the judiciary. अब वो oath कितने लोग करते हैं, नहीं करते हैं, कितने courts ये बहुत vary करता है. But some are very religious by book. They will hand you कि अच्छा गीता लाएं, कि बाइबल लाएं, कि कुरान लाएं. तो oath के बाद, or if you don't believe in God, then accordingly the oath is there that I do solemnly swear. उसके बाद chief examination होता है by the party that is called you, that is the state, the government. So the PP will ask you कि आपका name, designation, and on that particular date and time when you conducted the examination, what was your designation and what is your experience, things like that. Preliminaries के बाद, then they will ask you to tell you what was your role. So you will dictate each and every word that is there in the report. I know it is a time-consuming process, but it has to be done. And the typists are very fast. Even if they're not typing, they are taking it in shorthand, and they're very accurate. They write 100, 200, 300 pages in a day. So it is their बाएं हाथ का खेल. And after they have typed everything that is there in the report, it is marked as exhibit A/1, whatever that is court formalities. The PP will guide you at each and every step. And after that, your signature is very important. They will make a special mention that my signature is in my own handwriting and it has point so and so. Point A usko kar dete hain. After that, the opposite party, the defense counsel, will ask you any questions if they're pertaining to, that can save his client, the defendant, the accused. So the cross questions cross examination is a very, very tricky part. I would again, you can ask for a glass of water in the court, they will give you, because sometimes it can go very, haywire. You can there sometimes they will ask the defense counsel, Doctor Saab, I'm sorry, don't take it personally. I have nothing against you, but I have to ask you a question. Uh, are you an expert in conducting examination of sexual abuse victims? They can ask you, how many such examination have you done in the past? I say that you have taken money to do this examination. साथ में वो sorry भी बोल देते हैं in for respect of the doctor. But the idea is that we do not get nervous. Answer everything with a cool mind. That whatever your suggestion is wrong, and whatever I've done out of expertise, experience, and blah blah blah, then there could be to clarify certain objections which could go against your your statement as in chief examination. The public prosecutor, the party that is called you, can again ask certain questions to clarify them, and then again there could be a couple of recross examination. But with the years you learn to answer only things that are going to benefit the victim, the survivor. एंड मैं तो आंसर करने से पहले बहुत कैटेगोरिकली बोल देता हूँ डिफेंस काउंसिल को कि वकील साहब सोच लीजिए, अगर मैंने आंसर कर दिया इसको तो डैमेज हो सकता है आपका केस, तो वो विड्रॉ कर लेते हैं कभी कभी. तो यू वट एवर योर आंसर, वी डोंट हैव टू गो अबाउट द हिस्ट्री, वी हैव टू कॉन्सेंट्रेट. यस, दिस इज अ इम्पॉर्टेंट पॉइंट. हमको हिस्ट्री कुड बी बायस्ड, हिस्ट्री कुड बी रॉन्ग. We have to simply concentrate on our report, which is based upon examination findings done by us. So after that, the court asks you to, the question. There could be questions by the judge. The judicial officer can ask any question what they want to clarify anything. You have to answer them, and then you are asked to sign your. If their statement is in the form of 6 pages, you have to sign on each page and put your date below that. And if you have any doubt whatsoever, that the typist could have typed certain things or maybe could have misinterpreted. Oh, okay. Sorry. So that was it from my end. Yeah.
Thank you so much for so well explained every point. And I'd just like to ask you one question. Okay, how long this proceeding can go on? 1 day, 2 day, or it will take so many days?
So it depends upon case to case. If it is a simple case, small examination report, it could end in 1 day. And if the accused is a high profile person, it all depends on the profile of the accused. It could go for 2 days, 3 days, even 4. So it takes time. It varies. Yeah.
जस्ट वन लाइन की एक केस था जिसमें कोई जो हाई प्रोफाइल की सर बात कर रहे हैं, that was somehow that accused was related with one of the big political parties, so I was summoned to the court 7 times. लास्ट में मैंने बोला कि सर बहुत हो गया, ये फाइल भी मुझे हर बार अपने घर में ले जाके रखना पड़ता है और इसकी सिक्योरिटी है. तो द लास्ट जज वाज वेरी नाइस. उन्होंने अपने कोर्ट रूम की जेरोक्स मशीन पे पूरी फाइल जेरोक्स करवा ली, मुझे दे दी, कहा डॉक्टर साहब आपको कभी नहीं आना पड़ेगा. एंड आफ्टर दैट आई वाज नेवर कॉल्ड. So
you are lucky because sometimes CBI would take up the case and you might have to go again 3-4 times. You are lucky. वो नहीं हुआ.
Judges are also very sensitive.
I know.
अच्छा काम.
Next question, Malti. Next. So my next question is to Dr. Anita, and I want to know, can the defense lawyer ask very offending question to the doctor in the witness box, which often makes the doctor feel humiliated?
So Dr. Gaurav has already highlighted the same. Sometimes, defense lawyers may ask you very offending questions, but you should not get unnerved. You should keep your poise. They may ask you odd question, but sometimes if they are very offensive, even our public prosecutor might come to our help. They may say, no, this is not done. Then these kind of questions are not admissible. So the judge who is there, they might say that the lawyer cannot ask, the public prosecutor will help you regarding that defense lawyer cannot ask you such offending questions. But if they insist and the judge is sustaining the question, then we have to definitely give some answer to these even offending questions at times.
Well said. So it is all depends upon the judge only, who can object to it or who can say ki, yes, you have to answer it. To the all the defense lawyers' questions, whatever they are saying it. So aggressive question can be done and it has to be answered if only there is no objection by the judge. And if the judge says ki, no, you have to answer, you have to do it. Thank you, Dr. Anita. Next. This is again to Dr. Sashilata. What should a doctor do if there are topographical errors on the copy of evidence deposed in the court? Should the doctor sign the typed copy of evidence deposed even with the typographical error, or he has to do some correction or inform to whom he has to inform about the error and then get it corrected before he is signing it?
Yes, ma'am. So, ma'am, first I would like to tell that I have attended almost all courts of Delhi, Dwarka, Tisizari, Rohini, Kingsway Camp, Rouse Avenue, all the courts many a times. और जो मैंने रियलाइज करा जैसा कि गौरव सर ने बताया दैट द टाइपिस्ट इज परफेक्ट ओवर देयर. वो आपकी एमएलसी की कॉपी वहां फाइल खुली हुई होती है, ओरिजिनल कॉपी उसमें लगी होती है एंड यू हैव टू जस्ट रीड दैट आउट और उसको पढ़ के वो टाइप कर देते हैं. अब टाइपिंग उनकी ऑलमोस्ट 80 to 90% करेक्ट होती है. इफ समटाइम्स देन दे विल गिव यू अ टाइप्ड पेपर, वो आप पढ़िए, पढ़ने के बाद इफ देयर इज सम ग्रॉस मिस्टेक उस मीनिंग इज चेंज, आप उसको ठीक कर दीजिए तो वो दोबारा आपको टाइप करके कागज देंगे. करेक्टेड कागज पे आपको नहीं करना होता है, दे विल रीटाइप इट. आई थिंक डॉक्टर गौरव सर विल एग्री. और जब पूरा करेक्टेड कागज आपको मिल जाएगा तब आप उसको ठीक से देख के नीचे सिग्नेचर कर दीजिए. सो वी कैन नॉट एक्सेप्ट एनी टाइपोग्राफिकल एरर. हम उसको करेक्ट कराएंगे, करेक्टेड के ऊपर हमको अपना सिग्नेचर करना है. दिस इज द थिंग.
Yeah, so I like to add that yes, you should always see your statement before signing it nicely.
Yes.
Take your time. See, you are in no hurry. You tell the court judicial officer very politely that I need to take time to read it. So अगर वो कुछ ऑब्जेक्ट करते हैं तो you have full right to read it and then only sign it. अगर किसी भी वजह से कोई कोई होता है, मैंने सिर्फ भी देखे जुडिशियल ऑफिसर जो कहते हैं नहीं डॉक्टर साहब ठीक है साइन कर दो, तो it is our right to say no sir, I will not sign it without reading it. So we are in full rights to read it and then sign it, and please take this privilege to put your foot down. Otherwise you are not going to sign it. That's it.
Because they're going to quote this in future. Whatever is spoke, they will quote it in future. So it's very accurate whatever we spoke actually.
So now it's very clear that you have to sign at the end after getting all the correction and checked it. My next question. Malti. I'm going to ask all the panelists one by one. These are the few common questions which are asked to the witness, the doctor. So the first question has already been answered by Dr. Sangeeta in her lecture. But Dr. Leena, you can still again just repeat it, the answer to it.
Yes.
Whether the rape has occurred or not.
Yes, Dr. Sangeeta had very, very clearly pointed out that, rape is a legal term. So as a doctor, I cannot give the opinion whether rape occurred or not. So that should be very clear that we do not say that, give an answer that rape has occurred. Because that is a legal, it's a legal term. When we are asking this kind of a question.
Again to you only, Dr. Leena, whether the victim is habituated to sexual intercourse or not, which has already been answered by Dr. Sangeeta only.
Yes,
in her lecture.
yes. I mean, this is now not a question.
About it.
Yeah. This is now not a question which is, asked for. So we have not to comment on any whether past habituation or the history of the survivor of the victim. We have to make no comments about. So obviously, I'm going to say that I will not. I'm not supposed to comment on whether this victim is habituated to sexual intercourse or not.
Next, Malti. Next question. To Dr. Minani, could these injuries when you are examining and you have put your all the documents report in the report, they can ask you ki, could this injury be caused by any other means other than rape or sexual assault, and can these injuries can be self-inflicted, then what will be your answer as a witness?
So this is a very common question asked by the opposition lawyer. So what happens is we have to clearly be very clear what is a self-inflicted injury and what is an injury caused by any struggle or physical or sexual assault. So basically, we have to just mention if you are very sure that they are not, so we have to say no, these are not caused by they are not self-inflicted. And if they ask us to enumerate, because we can then say, because most of the time the self-inflicted injuries, they are planned, pre-planned, and the person does not hurt themselves deeply. So they're very clear-cut, shallow wounds, incised shallow wounds. There can be multiple attempts on that wound and are on the accessible part of the body, like limb, so they part, pad, abdomen, and never on the face or anything, but nobody wants to disfigure their face.
Yeah, thank you, Dr. Minali. Actually,
they
what
cannot be-
I'm going to ask are usually the repetition of the questions and answer given by the Dr. Sangeeta in her lecture only. And to cut short, because we are running short of time, they can ask Dr. Anita ki why there are no injuries in case or in case of the gang. So already highlighted well by Dr.
Yeah.
Sangeeta in the. So the next question.
So in that case, that means the survivor was so overpowered by the gang or the assailant that she could not even revolt. Sometimes if a condom is used or some lubricant is used, there might not be any injuries. Or she was overpowered, she was drugged, or she was under intoxication, or she was threatened. Suppose the accused has put knife on her head or on her throat that if you will shout, then I'll do this, I'll do that, I'll hurt your family member or so. So sometimes the survivor might have been intimidated. So there may not be any signs of injury. So there are so many reasons that Sangeeta ma'am has highlighted that it might not.
Yes, very true, Dr. Anita. And thank you for your answer. Now, the next question for Dr. Sashi, did you actually notice the injuries on the body of the survivor? What will be your answer? Yes or no? Dr. Shashi?
I think she has been disconnected most.
I think I can answer the question that we have to say yes. We have seen ourselves the injuries because there is no this thing that we have not seen. What we have documented in our report is only after examination.
Yes,
You can show the medical legal report also that you have documented on the pictorial representation.
Yeah.
Next, Malti.
Next,
to Dr. Gaurav, how you can say ki what is the time since injuries has occurred? How you will?
So so this is, medically speaking or scientifically speaking, this is very difficult to comment upon, and we have to be very cautious. We can categorically or with confidence time the injuries only in case of bruises and to very little extent in the case of abrasions. But sometimes if there is a lacerated wound or an incised wound, it is almost impossible to time a wound. So there are definite color changes in case of a bruise, as we have learned in our MBBS curriculum, and accordingly we can, roughly time in matter of sometimes plus minus 1 day or 2 day or 3 day about bruises only, and to a very little extent about abrasions. So that is all we can say about the injuries. And sometimes they don't ask you directly, okay, how old the injuries are. They ask you, okay, is it possible that the injury is 7 day old when the the victim
misdirect you.
yeah, the victim is saying that the incident occurred 7 days ago, or there could be, I have seen cases where there are two sets of injuries. One is fresh when the survivor came to the police, and the second time could have been 3 days ago. So we have to be ready for all these things. And if it is not possible, we are under no pressure to give a opinion regarding the time. If it is not possible, then we can simply say it is not possible to comment upon the age of the injury, how old the injury is. Dr.
I
Raj?
think, Dr. Bukaria, we
Gauri.
have covered most of the
Yeah.
questions,
Yeah.
and
So
we can now.
wind up karen.
Because
Because
these
these are the
are simple
usually the
questions.
same.
Madam, wind up.
So I
Thanks.
think
So we can wind up. And at the end of the discussion, I thank all my